A complaint has been filed, so we'll be doing an arraignment today as well as a detention hearing, shelter hearing. Before we bring out the juvenile in this matter, is there anything the court needs to know? If we're to be bound over. So, in light of the public's interest and need to know judicial proceedings, I believe that the court should be open, as all my hearings are for juveniles. So, on that note, would we please bring the juvenile out?
Still bring parents? Yes.
Daniel, today we are here for two purposes today, Daniel. One is a formal proceeding to determine whether or not you should be confined in the detention home pending the outcome of this matter at this present time. Also a denial stage, whether there should be an admission or a denial. Do you understand that? Your attorney could fully more explain that, but what it basically means is I want you to know that you have the right to remain silent here today, and that you have no opportunity or reason to speak today. But today is a procedural matter, and your attorney can more explain that to you.
Your Honor, I've had an opportunity to discuss with Daniel what's occurring here today. At this time, he's going to enter a denial of the charges against him. To explain to him his constitutional and statutory rights as to this proceeding, and I think he understands what's going on.
Thank you. And you have been served with the complaint, correct?
Yes, Your Honor. And
I believe there's 4 counts. Is that correct?
That's correct, Your Honor.
Yes, State of Ohio, would you please indicate what those counts are?
Count 1 is murder, count 2 is murder, count 3 is felonious assault, and count 4 is felonious assault.
And for purposes of the record, I will enter a procedural denial on all counts. Furthermore, we're here on a shelter hearing, detention hearing to determine whether or not a release is appropriate. Would anybody like to be heard on that matter?
Yeah, Your Honor, the state requested a remand.
Reasons?
Nature of the charges, the severity of the crime due to the death of the victim, obviously, and also there was a difficulty of him surrendering himself to the court during the period of time that he was unlocatable.
Counselor?
Yes, Your Honor, if I could briefly address that.
Yes.
In terms of the seriousness of the crime, it's obvious that this is a serious allegation against the child. However, there was never 1 second where I myself as counsel and the prosecutor's office is aware of this. I knew where Mr. Kovarbasich was at all times. His family has a single vehicle which was seized in connection with this matter, which is why they were staying with family. There was no difficulty in locating him or turning him in other than not contacting me and trying to go around me in order to contact the child directly. I was called by the Lorraine County Prosecutor's Office yesterday. I said that Mr. Kovarbasich is locatable. I know exactly where he is, and we will be turning him in within the hour. That's what has been done. He is not a flight risk. He's lived in Lorraine County for his entire life. His family is here in the courtroom. They're not going anywhere. Everything that this kid has is in this county, in the city of North Ridgeville. Like I said, he is charged with a very serious crime. He voluntarily turned himself in. I think that release is appropriate to his parents' custody.
Very well. Based upon the standards that I must determine under the Ohio Revised Code for detention, as well as the juvenile rules, I believe that at this point in time, a remand to the detention home will be appropriate. Certainly, I will take up this consideration whether a release is appropriate in every proceeding in this matter. But right now, as charges have just been filed, the nature of the charges and the allegations that have happened, and the fact that it has taken several days, I believe, for the child to be brought forth to the court after the incident, I will, in fact, issue a remand to the detention home today. We will be setting this matter for a probable cause hearing on
February 12th, Your Honor, at 10 o'clock in the morning.
June 12th, 10 a.m. The court will further order a psychological examination of the juvenile. That's a standard protocol that I do. Normally it's done as a non-mandatory bind-over. But since this matter, I still believe it's helpful to the court. So what we will do then is I will enter the procedural denials and will remand the juvenile to the detention home at least until February the 12th at 10 a.m. Any other proceedings or any other matters I should be aware of? Very well, based upon the information that I have, I will adjourn this matter until 2/12 at 10 a.m. and certainly make sure that psychological evaluation starts. There will be individuals, Daniel, that come out and speak with you on psychological evaluation. Cooperate with them. Anything that happens or is said to them will not go back to the attorneys, and as a matter of fact, under the law, cannot be used against you. Understand? Your attorney can describe that more in full. We'll be adjourned until the 12th. Thank you.
Thank you, Your Honor.